I wanted to start this morning with a number, and that number is 27. 27 is the number of days that we have all been together, believe it or not. And I have the distinct privilege of being the first one here before you and telling you thank you. On behalf of my team, on behalf of the citizens of this county, and on behalf of Diane McIver. And I want to say thank you not just for being here and sharing all that time that you've had to share with us, from being away from your life, from your family, from your job, but for the work that you've done throughout the course of this trial. We have been able to see you taking notes, paying close attention, asking questions, and listening to the important evidence and testimony in this case. So again, on behalf of my team and Fulton County, thank you. Because I'm first up here, I'm going to talk to you a little bit about the law in this case. At the close of closing arguments, Judge McBurney is going to read to you from a charge, or your instructions basically for what you do back there. And he is going to read you a series of charges that relate to sort of how you apply the facts to the law in this case. And he is actually going to give you a copy of that charge. So when he reads you the law, you don't have to take it down word for word or make a copy of it. And part of my job now is to really kind of highlight with you some of the most important parts of that charge that you're going to hear from the court. But the first thing I want to talk to you about is your duty under the law. Each of you are here for a reason. And you are here to be fair and impartial jurors honestly seeking the truth about what happened in that SUV on September 25th, 2016. You are not to seek doubt, but just to seek the truth about what happened. You have a duty to follow the law as charged and as instructed to you, a duty to deliberate with one another, to talk about other people's points of view and go over everything that you've heard, and to consider the exhibits, the testimony, and all of the evidence in this case. There's a lot of things going on outside this courtroom. It is your job to make a determination based on what you have heard inside the four walls of this courtroom and from that witness stand right there. That's your job. You're not to concern yourself with punishment or sentencing, simply the guilt or the innocence of this defendant as to every count in the state's indictment. In the indictment that you'll have back there with you, there will be 5 counts total for your consideration. 2 of the counts have been removed from your consideration, and you are not to concern yourself with that. It should have no impact at all whatsoever on your deliberations. The first 4 counts are related to the death of Diane McIver. It's the murder, the aggravated assault and felony murder, and the possession of a firearm during the commission of a felony. And 1 count related to influencing Danny Jo Carter. That's the witness influencing count. Before I talk to you in detail about each of those counts, I want to talk to you about the concept of intent, which is important in this case, and the judge is going to charge you that intent is an essential element of any crime, and it must be proved by the state beyond a reasonable doubt. Criminal intent is not an intent to violate a law, but it's just the intent to do the act. It's the purposeful doing of something. And in this case, intent may be proven by acts, conduct, and it can also be inferred when it is the natural and necessary consequence of an act. When you aim a loaded gun to the back of your wife and you pull the trigger, the natural and necessary consequence of that act is shooting her. And you can infer from that conduct and from all of the circumstances that surround that shooting that the defendant had the intent to do it. Words, conduct, demeanor, motive, and all of the other circumstances, like I said, of the shooting could and should be considered by you when you are determining whether or not intent has been proven by the state beyond a reasonable doubt. I want you to think about, when you're thinking about the concept of intent, sort of the before, the during, and the after. You have, in this case, 27 days of information about all of the circumstances that surround this shooting, but it's important. And you all were patient as you listened to a lot of people tell you about very small details of what happened in that weekend and even outside of the weekend related to this shooting. But every single person that came in here and testified and swore to tell the truth and looked at each one of you gave you a critical piece of information that you needed to do that job back there. And so when you're considering intent in this case, I want you to think about the before, the during, and the after. I want to talk to you just about a couple of things with the before. You heard a lot of testimony about the plastic bag in this case. You heard testimony from Danny Jo Carter that she had ridden in that car before and the gun was in there. She had never seen it before in this condition. You know that the gun was actually fired based on the evidence, direct and circumstantial, that we'll talk about in a little bit, but it was fired inside that plastic bag. And I want you to think about Tanner. Tanner came in here and testified that he had just essentially worked at the ranch with his girlfriend for about 5 years, that he knew the McIvers and had no issues with them. But he remembered something important about that Sunday, something that stood out to him because it was unusual, something that he probably won't ever forget. The defendant approached him and asked, "Can you give Danny Jo Carter a ride home?" A couple who lives in Athens and who would be driving in the complete opposite direction. But it's important. And when I sit down and after defense counsel is finished, Mr. Rucker is going to talk to you in detail about why that's important, about all of the circumstances of the before. Again, you heard in detail and you actually got to see for yourself the during yesterday. You heard testimony about where that gun was along that trajectory. And you were able to actually sit in the seat and feel that perspective for yourself. The gun was aimed. The gun was in perfect working condition. This was not a malfunctioning gun. This gun didn't just go off. This gun had the trigger pulled. And we know, of course, about the after. You heard evidence about the defendant's conduct at the Emory University Hospital. You heard that he told Danny Jo Carter to be careful. There could be women out with baby carriages. As Danny Jo Carter is trying to shave off every second she can to save her best friend's life and do what she needs to do to stop that internal bleeding. You heard the testimony of Dr. Sellers about the damage that was sustained to her body from that impact, from that full metal jacket that hit her center mass. You heard that the day after this murder, on the Tuesday, the defendant is cataloging her jewelry well before he hires Stan Smith or is advised by anyone else. You heard and will hear again about specific lies that he told to the Atlanta Police Department. That he was holding her hand as they came into the emergency room. And he stood by her side in the trauma room and held her hand. He lied about that. And you heard that he tried to bribe the DA. There's a bonus in it for you. The judge is going to charge you on a legal concept called accident. And he is going to tell you that if something is an accident, that you should not and cannot convict the person. An accident is misfortune or accident when there is no criminal scheme or intention, that concept that we've just been talking about. This happens when there's no foresight, there's no expectation of what's about to happen. In this case, we know by way of the evidence that this is not an accident. This is not a malfunctioning gun that just went off. The gun has been sitting in this courtroom for all these days with no issues, and it had no issues that night. You heard the testimony of many witnesses about that. I have an example up there because, when you think about accidents, something truly unexpected. If I was driving into work this morning in a brand new car that I've had no issues with a brand new set of tires, and one of my tires just explodes, I run off the road and strike another car and I injure someone. That is an accident. What we have in this case is no accident. Instead, we have a gun in perfect working condition, and we know from the testimony and from common sense that guns don't just go off. We have a gun that was not in full cock, which is described by Steve Maples in that statement, which means that hammer, that shrouded hammer that Zach Weitz will talk to you about, it was not pulled back. And that is important. That is so important in this case because we know if the gun was not in full cock as described by the defendant, then it is 12.25 pounds to squeeze. That gun is in evidence. And so if you want to feel that, you should ask the judge. And that would be appropriate for you to do. If you want to feel what that 12.25 pounds feels like, you should ask the judge. We know that the defendant told the Atlanta Police Department that he was handling the gun and it just went off. But from the testimony and from the facts in this case, we know that that is not true. That's not what this case is. You saw yesterday and you heard testimony about where the muzzle of the gun is, where the gun is actually pointed when it fires. We know that it's at least 6 inches from the seat, and we know that it is right to left and slightly upward. We know that it hits Diane McIver right in the middle of her back, just about an inch left of her midline or her spine. And if it had not hit a vertebrae on the way through her body, it would have possibly traveled through her heart. We know the injuries she sustained are just a few centimeters below her heart. This is no accident. The charges in this case are 5, as I described to you before. The first one is murder. The judge is going to instruct you that a person commits the offense of murder when that person unlawfully and with malice aforethought, which I will talk to you about, causes the death of another human being. Under the laws of this state, we are not required to prove premeditation of any kind. And under the laws of this state, we are not required to prove motive. In this case, though, you have evidence about the motive of the defendant, his state of mind at the time that this killing was done. And the judge is going to tell you that evidence of motive, if any, in this case, has been admitted for you to determine that, the defendant's state of mind when this actually happened. In this case, we know that the defendant was under pretty extreme financial stress, that he was living up here and earning down here. He wasn't willing to make a change to that lifestyle. We know that the ranch was his pride and joy, and that ownership of the ranch had changed over the years because now Diane McIver was on the deed, and she had a different intention. All of those things can be considered when you are determining the defendant's state of mind at the time of this killing. The concept of malice aforethought is something that you need to find the murder count in this indictment. And there are 2 types of it, express and implied. But legal malice isn't ill will or hatred. We don't have to prove that the defendant hated Diane. That's not what legal malice is. It's just the intention to kill without a justification, excuse, or mitigation. If this killing is done with malice, no matter how short of time that developed, then it is murder under the law. Malice can be formed in an instant. In an instant. It can be formed the moment that your hand wraps around that trigger. Like I said, there are 2 types of malice. The first is express, and that is the deliberate intention to kill. And you can show that by external circumstances. In this case, we have quite a few of those. The actual dynamic of the shooting itself. We know that she shot in the back with a loaded handgun with mixed ammunition, but she is shot with a bullet that is a full metal jacket, something that's going to penetrate surface as well. It didn't break apart when it hit the seat. It went through the seat and into her body. We know that he shot her by squeezing that trigger using 12 pounds of force. All of those things can have you determine, based on the evidence in the testimony, that this is express malice. But malice can also be implied. And you can infer that based on the conduct and the circumstances of the killing. The judge is going to tell you that it happens when no considerable provocation appears, and when the circumstances of the killing show an abandoned and malignant heart. In this case, the conduct immediately after the killing is so important. You have shot your wife in the back, close to her heart. She is bleeding out. Her body is in that process that Dr. Sellers and Dr. Henninger described where she's shunting off blood. Her body is in life-saving mode, sending blood to her vital organs so that she can fight to stay alive. And those few minutes that follow that shooting is precious for her because those are the few minutes that determine if she lives or dies. In those few minutes, this defendant is telling Danny Jo Carter, be careful. There could be people out with a baby carriage. Be careful. And he directs her to Emory University Hospital on Clifton Road. Claude McIver works at Fisher and Phillips just 2 blocks from the scene of this shooting. And they drive to Emory University Hospital in the defendant's 2013 SUV with a working GPS navigation system. In the back seat, just to the left of his knee, is a plugged-in, charged-up iPhone. There is no call to 911. The first call this defendant makes is to his criminal defense attorney, Steve Maples. The next count in the indictment is felony murder. The judge is going to tell you that a person also commits the offense of murder, so you may be guilty of murder and felony murder. And felony murder is different because it just is with or without malice. You do not need malice. Someone dies basically when you're in the commission of a felony. Intent to commit the underlying felony, which in this case is aggravated assault, is all that's required when determining whether or not the state has met their burden as to felony murder. If you find under the law and the evidence in this case that the defendant was engaged in the commission of an aggravated assault, then you would be authorized to find the defendant guilty of felony murder because Diane McIver died as a result of that assault. And you don't need to determine malice in that circumstance. Any act that the defendant is engaged in that's necessary for the performance of that aggravated assault, so squeezing that trigger and firing that bullet, is an act that is a substantial step towards that felony, and it's going to tie into the felony murder. You must also find under the law that the underlying felony is inherently dangerous. In this case, we have aggravated assault with a deadly weapon, which created a foreseeable risk of death in this case, a loaded handgun, and the trigger was squeezed. The judge is also going to charge you on aggravated assault, and an assault is just when a person attempts to commit a violent injury towards another person. In this case, we have charged it by shooting Landa Diane McIver with a deadly weapon. You also need to determine that we have proved that a firearm is a deadly weapon, which the judge is going to tell you that as a matter of law, it is in this state. That is one less thing that you don't need to consider. The judge is going to tell you that as a matter of law, that weapon is a deadly weapon that satisfies that count. Possession of a firearm during the commission of a felony. The judge is going to tell you what the felonies are. In this case, murder, felony murder, and aggravated assault with a deadly weapon. If you find that the defendant committed any of those felonies and during that felony he had on or within arm's reach the handgun, then he is guilty of possession of a firearm during the commission of a felony. And finally, influencing a witness. In this case, it's count 5. And count 5 is about that conduct at the hospital, Danny Jo Carter. Unlawfully and knowingly are the elements engaged in misleading conduct towards Danny Jo Carter. And you all heard a lot of testimony from Danny Jo about the circumstances of that conversation. And you heard about her telling other people about that conversation. It's something she remembers in the timeline of the night because of how it unfolded, because of who the defendant is to her, and because of what she had just witnessed in the car. She pulls into the emergency room and she told you about the franticness of the emergency room in those few minutes as they're first getting Diane into the trauma room too. And she told you that the defendant approaches her as uniformed officers from Emory Police Department and security officers from Emory sort of approach the group, and he tells her, I don't trust these guys. I know how these things can go. Just say that you're here as a family friend. Just say that you're here as a family friend. But she had just driven the defendant into the emergency room. Why? And the next element of what we've charged in count 5 is that it needs to be with the intent to prevent communication with a law enforcement officer. In this circumstance, we know that that's absolutely satisfied because he makes this comment as the law enforcement officer is approaching the group. The uniformed police, that's what causes him to say, I don't trust these guys. The judge is going to charge you on another charge as well that's not in the indictment called involuntary manslaughter. And you're going to have back with you a verdict form. It'll look like this. And the first count of the verdict form has the murder count on it. And one of the blanks under the murder count is, we the jury find the defendant guilty of involuntary manslaughter. I'm going to ask that you don't check that box because the defendant is not guilty of involuntary manslaughter, but he is guilty of malice murder beyond a reasonable doubt and all of the other charges in this indictment. One of the first things the judge is going to tell you about involuntary manslaughter is that it is the unintentional cause of death by and through the commission of reckless conduct. So in this instance, there is no intent to cause a death. You just cause it during a reckless act. And the language is a lot, but he is going to read it to you that there is, when you cause bodily harm to another person by consciously disregarding a substantial and unjustifiable risk, and it constitutes a gross deviation from a standard of care that a reasonable person would use. In this circumstance, the facts and the evidence of this case are malice murder, not involuntary manslaughter. In this example, the shooter doesn't have any intent to kill. A good example is texting and driving. If you are texting on your phone and driving, and because of that, you accidentally swerve over into another lane and you kill someone because of that accident, that is a reckless act and you cause a death. So that would be involuntary manslaughter. But you don't have any intent to kill the person. And there's nothing about the circumstances or the conduct of that situation that could lead you to find intent as to the killing. That's involuntary manslaughter. In this case, you have evidence before, during, and after of this defendant's intent. The presumption of innocence is something that the defendant came into this process with. And you can think of it like a coat. He comes into the courtroom cloaked with a jacket of innocence. And each piece of evidence that comes into this courtroom raises the temperature in here. And as it gets hotter and hotter, eventually that coat comes off because the state has met their burden beyond a reasonable doubt and the defendant is no longer innocent. And as we sit here today and I have the pleasure of addressing each and every one of you, he is guilty of every count in this indictment. The state has the burden of proof in this case. Judge McBurney has told you this a couple times and he will do so again. And he's going to tell you that there is no burden of proof on the defendant and it never shifts to the defendant. It's our burden and we have to prove each and every element. It is not to all doubt or not to any mathematical certainty. It's just what it sounds like. It's the doubt of a fair-minded, impartial juror just honestly seeking the truth. It's a doubt based on common sense and reason. It's not a vague or arbitrary doubt. There will always be doubt. There are very few things that we can know with 100% certainty. This is a doubt based on common sense and reason about the evidence, a conflict in the evidence, or a lack of evidence. I have this example up there. I usually, when I talk to jurors, talk about rain or something else in the weather, but with us, we have to do the pollen example. If you guys are like me, this trial has completely consumed your life, and it's hard to find any time to run errands or do anything else. I'm sure your weekends are packed with that. So last weekend, I found some time to actually wash my car for the first time in about a month. And I have the pleasure of spending most of my weekend here in this building So after I wash my car, I come down and I park on Central Avenue right in front of the courthouse. I get out of the car and I go in. And I spend the next few hours in here getting prepared to come address you all. When I come out to my car, I notice that my row of cars, which is right underneath a tree, is covered in this yellow dust. I know, because of common sense, because of reason, because all the circumstances surrounding the week, including the fact that the judge told us that it was record-setting highs of pollen, that is pollen on my car. And Mr. Samuel or Mr. Harvey might want to tell me, well, Kara, you didn't do any testing on the pollen. You didn't take a sample of the substance and send it off to the lab. You know, it could be someone who came into the courthouse, a disgruntled employee, and hosed down the first row of cars with the yellow dust. It could be. It's possible, but it's not reasonable. You know beyond a reasonable doubt that that's pollen, and if you didn't, you would never get in your car and pull off. That is something that you do every day. You make inferences and you come to conclusions based on your life experiences. And this process is exactly the same. Your job is important, but your common sense is how you get there. When you go back into the jury room, we're going to take your phones and your iPads, but we are going to ask that you use your common sense when you make an evaluation as to exactly what happened in this case. There are two types of evidence that you'll have, direct and circumstantial. Evidence can be one or the other or both. The law assigns no greater weight to either. Direct evidence is something that you see, touch, taste, hear. In this case, we have the sound of the gunshot that Danny Jo Carter described to you. We have the printout, the readings of the EKG from the defendant's anxiety attack that Dr. Rosing talked to you about. The statements made at the hospital, Danny Jo Carter telling you what she looked and heard the defendant say to her. Those are examples of direct evidence. Circumstantial evidence is evidence that points to a conclusion based on inference. In this case, what I just talked about, that vehicle had GPS. That car had GPS. The guns at the ranch. All of the testimony about firing a gun, about gun safety, about knowing what to do with the gun and where not to point it. The testimony about the will, the information and what you all know about how much Diane loved Austin. That's all circumstantial evidence of different facts in this case. And the law assigns no greater weight to either. In this example, when you pull into the gas station, it's a good way to think about circumstantial and direct evidence. You kind of pull up and you're on autopilot. You put the nozzle into the tank and you click it. Swipe your card. You can hear the sound of the gas, see the cost getting higher and higher as time goes by. You put the nozzle back in and you get in your car and you pull off. Again, you didn't do any testing. You didn't actually see the gas go into your car, but you know beyond a reasonable doubt that you got gas and it costs money because of direct and circumstantial evidence. You maybe smelled the gas and you saw the money. You know beyond a reasonable doubt because of what you just experienced in that situation that you got gas and that you can pull off. In this case, the state must prove venue for counts 1 through 4. The venue is Fulton County, and you've heard testimony about where the actual shooting occurred. For count 5, the judge is going to charge you that venue is actually appropriate where the influencing occurred. That's Emory University Hospital in DeKalb County that you heard about, or where the shooting or the underlying event itself actually occurred, which we know is in Fulton County. He's going to tell you that the testimony of a single witness in this case, if believed, is sufficient to establish a fact, and that generally there is no legal requirement of corroboration. You can apply this when you're thinking about Tanner's testimony, the circumstances and the evidence that Danny Jo Carter testified to you about. And finally, I'm going to talk to you about credibility. It's you, the jury, that determines the credibility of these witnesses. It's not me, Mr. Rucker, anybody on my team, and it's not anyone on the defense team. It's each of you. And this is important because that's really why we tell the jurors when we start a direct to look at you guys and introduce themselves, because it's you that's really evaluating each of these jurors, each of these witnesses. And when they testify, you should consider the way they testified. How did they know what they told you? the probability or improbability of their testimony, any motive that they had to lie. Rachel Stiles and Bill Crane came in here and told you that they still loved and respected the defendant and that they cared about them very much, but they also told you difficult things for the defendant. Bill Crane told you that the defendant asked him to lie repeatedly. And Rachel Stiles told you that she was certain that she had her hands on Diane's new will. There are things in this case that have been admitted for you to consider the defendant's state of mind. Actions, words, and conduct that show the defendant's consciousness of guilt. In this case, you heard from multiple witnesses who talked to you about evidence related to that concept. These are just some of them. Danny Jo Carter, Craig Stringer, Bill Crane, Dr. Marty Sellers. I want to leave you with this one. Craig Stringer came in here like many of these witnesses and again told you that he respected and loved the defendant. He told you that he's actually golfed with him 3 or 4 times after he killed his wife. But he took that stand and he swore to tell the truth. And he told you something that can let you in to the mind of the defendant. He told you that immediately after this happened, on the morning of Diane's death, they talked on the phone. And the defendant said to him, there's been an accident on Hill Street, and Diane didn't make it through the night. It's in the next few hours that Craig Stringer comes into contact with Billy Corey. And Billy Corey tells him that that's not what happened at all. Diane had been shot, and she died. Craig Stringer confronts him about this and says, what is this story that I just heard? And he says, I didn't want you to get mixed up in it. You can consider that conduct and that mindset when you are determining the intent of this defendant. In just a few minutes, you will hear from defense counsel, and then at the close of the argument, you will hear from Mr. Rucker, my colleague. I again want to say thank you on behalf of our team. It's been a privilege to present this case to each and every one of you, and we are confident that the evidence in this case has proved that the defendant is guilty of every count in this indictment beyond a reasonable doubt. Thank you.